Hi, my name is Paul Schiff Berman, and I'm a law professor at the George Washington University Law School. And each week I'm going to be bringing you the top 5 legal issues of the week and try to explain to you why they matter and what their significance is. So, for this week, the first story is, of course, the Trump administration calling in the National Guard to Washington, D.C., and attempting to take over the D.C. Metropolitan Police Force. Now, there's no dispute that Trump does have the legal authority to call in the National Guard, just the same way that a governor of a state would. It's extremely problematic because it militarizes the city in a way that's antithetical to American values, but it is legal. On the other hand, Pam Bondi's efforts to take over the Metropolitan Police Department and dictate policies are almost certainly not legal. The D.C. Home Rule statute does not give the president the ability to take over the police force. It only provides that if the president determines that special conditions of an emergency nature exist, which require the use of the police force for federal purposes, then the president can direct the mayor to provide those services, but he can't take over the department. So, as the federal district judge hearing the case earlier this week said, Trump can direct the mayor to order the police to, for example, provide support for immigration enforcement, but he can't replace the command structure or start dictating policy. Okay, our second big story of the week is a D.C. Circuit ruling that the Trump administration cannot withhold information from Congress as to how the administration is spending, or more precisely, not spending, congressionally mandated funds. This is part of a very important battle that's being litigated in various contexts in various lawsuits. The broad issue is whether the executive can refuse to spend funds that Congress has authorized for specific purposes. So, for example, when Congress passes spending legislation saying that a particular program, let's say within the Food and Drug Administration, should receive a certain allocation of money, that is a law passed pursuant to Congress's spending clause authority under the U.S. Constitution. And the executive then has the obligation, under Article 2 of the Constitution, to take care that the laws are faithfully executed. So, if the executive then says, I don't support that program, I'm not going to spend that money, or I'm going to shift those funds to other priorities, does that violate the Constitution? The decision in this case suggests that it might, and for that reason, the court ruled that the executive has to at least make available to Congress information about what it is spending on which programs. On the other hand, a different D.C. Circuit panel this week threw out a lawsuit aimed at blocking the Trump administration's decision to defund USAID, despite congressional appropriations for it. But that case wasn't decided on the merits. Instead, the court said, in a 2-to-1 vote, that the plaintiff's suit wasn't properly brought under the Constitution, but under the Impoundment Control Act, which is a federal statute, and that statute can only be enforced by the General Accountability Office, which is an arm of Congress. So the plaintiffs in that case were essentially the wrong plaintiffs. Now, this strikes me as a ludicrous way for the court to sidestep its obligation to adjudicate an important separation of powers question, but it does suggest that that question is still open to be decided in a future case. Now, third, the Federal Circuit is now hearing arguments on the legality of Trump's tariffs. This is separate from the question of whether tariffs are a good idea, which almost all economists say they are not. But is it even legal for the president to impose them? And the answer to that question is likely no. Unlike with a lot of the power grabs of the Trump administration, here there's no real credible argument that imposing tariffs is some inherent presidential power under Article 2 of the Constitution. Instead, the authority to raise tariffs, if it exists, comes from a congressional statute called the International Emergency Economic Powers Act, often referred to as IEPA. That statute gives the president power to impose economic sanctions on other countries in an emergency. So first, it's not clear that tariffs really count as the sort of economic sanctions that are even contemplated under IEPA. Perhaps specific targeted sanctions would be justified, but not across-the-board tariffs. Second, even if the imposition of tariffs were permitted, under any plausible definition of emergency, this shouldn't count, because whatever economic harm Trump claimed to be addressing, it was not sudden, unforeseen, or necessary to be combated immediately, as evidenced by the fact that he's repeatedly imposed and paused the tariffs for months. And third, Trump's public justification for many of the tariffs don't speak to an economic emergency at all, but instead are based on disagreements about law or policy. For instance, imposing a tariff on Brazil because it is prosecuting former head of state Jair Bolsonaro. Now, the U.S. Court of Appeals for the Federal Circuit is currently considering the legal question, but it seems clear as a matter of statutory interpretation that Trump needs to go to Congress to pass his package of tariffs. Any other reading of the statute would give the president far more discretionary authority than the text of the statute seems to allow. But, as with many other legal challenges in the Trump era, the outcome will rest on the court's willingness to limit executive power. Okay, fourth big legal story is that a federal district court blocked the Trump administration's attempt to launch an investigation into media matters. The judge said the Federal Trade Commission's investigation violated the free speech rights of this liberal watchdog group, which had published research critical of Elon Musk and his social media platform X. In May, the FTC had begun examining whether Media Matters illegally colluded with other advertising advocacy groups to pinch off revenue from X. Media Matters reported in 2023 that ads on X appeared alongside anti-Semitic content. Media Matters sued the FTC, calling the inquiry a campaign of retribution waged on behalf of Musk and the Trump administration, and on Friday the judge agreed, calling the inquiry a retaliatory act and essentially blocking it from progressing, though the FTC can still appeal. According to the judge, this case presents a straightforward First Amendment violation, and it should alarm all Americans when the government retaliates against individuals or organizations for engaging in constitutionally protected public debate. Fifth, and finally, I want to talk about a newspaper article I saw recently. There was a quotation in a Nebraska newspaper from a rural resident who said, well, there are government programs that I would like to see discontinued or cut back, especially those that don't affect me. But the ones like the Postal Service, well, yes, we count on them here in our rural area of Nebraska, so that shouldn't be cut. And of course, they do count on the Postal Service. Mail is ridiculously cost ineffective in rural America, and that's part of why the U.S. Postal Service experiences annual losses. But you've got to understand that the government isn't supposed to be profitable. It's supposed to serve the common good, even when that good is mail service in areas with very low population. Now, liberal urban populations have been subsidizing rural America for decades. Tax dollars go to government subsidies for rural roads, rural phone lines, rural mail service, rural hospitals, because that's what a shared society does. But in return, rural conservatives have demonized the very government that sustains their communities. And worse, they've vilified the very people, urban liberals, who've supported those subsidies for years. And now, this man was just admitting that he only wants to fund what affects him. But imagine if urban populations said the same thing. Well, rural broadband doesn't affect us. We have fast internet, so who cares about rural people? That expensive rural postal network doesn't affect me. Why should I pay for it? All that costly telephone infrastructure, well, let it rot. The Department of Agriculture, I'm not a farmer. Cut the whole department. Medicaid funding for rural hospitals, well, I've got plenty of hospitals. Rural road maintenance, let them crumble. Black lung benefits for coal miners, tough on them. Opioid epidemics in rural towns, well, let them pull themselves up by their bootstraps. None of it affects us, so let's cut it all. Now that's a reprehensible and horrifying set of arguments. Why? Because we're supposed to believe in a basic social obligation to each other, even when it costs us something. But this rural person doesn't care about programs that don't directly benefit him, even as he insists that everyone else subsidize his postal service. But that's not how the social contract works. Government is based on a mutual agreement that we all pitch in so that no one, no matter where they live, falls through the cracks. It's a recognition that the government is the tool we use to express collective values, not individual preferences. So when conservatives start picking and choosing what parts of society are worth funding, based solely on their own needs, they're not just being selfish. They're breaking the very foundation that holds this country together. Those are my top 5 legal stories for the week. I'll be back next week. Please be sure to tune in and subscribe.